Hell, are you laying down on the couch before 6 p.m.? Yes, I am. Okay, stick with me because this one's a little bit, you just have to follow it a little bit. So if you want to know about the whole attorney's fees, how all of that works, go in the TikTok Law School playlist. There's a whole video on attorney's fees. But basically, if you prevail in a case, if there is a statute or a contract provision that allows the prevailing party to recover their attorney's fees, then you can file a motion asking the court to do so. There are no contracts in this case, at least as of yet. So all of the bases that the people on the Lively side who've been dismissed would use to get attorney's fees come out of statutes. And there are many statutes on the books that say if you are involved in a claim that includes this statute and you win, this statute says that you get your fees for having won that case. Not all statutes do that, not all laws do that, but some of them do. And the two that are at play here are the New York anti-SLAPP statute and this California 47.1, which is the privilege for complaint of sexual harassment statute, which is sort of anti-SLAPP in nature, even though it's not called that, and even though California has a separate anti-SLAPP statute. These are the ones that the parties could rely on to try to get attorney's fees, to say, I prevailed in a case where I was sued and this statute applied, ergo, this statute says that I should get the people who sued me to pay for my attorney's fees. But the thing is, both the New York anti-SLAPP statute and 47.1 in California are procedural laws. There are two kinds of laws. There's substantive laws and there's procedural laws. Substantive laws say thou shalt not. And procedural laws say this is how this works. And both the New York anti-SLAPP statute and 47.1 are procedural laws because they speak to a process for getting cases dismissed outside of the normal dismissal processes in the rules of civil procedure. So they are not laws that say what people can and can't do, what does and doesn't violate the law. They are laws that give you a process and a procedure for getting a case kicked early because of the circumstances, which makes them procedural laws. Why does that matter? That matters because there is law out there that federal courts can apply substantive laws of states, but they cannot apply procedural laws of states. In other words, Judge Lyman can make a decision about whether California has a claim for civil extortion because that is a substantive issue of what does and doesn't violate the law. But Judge Lyman cannot make a decision about how California procedure works because he is only allowed to interpret and enforce the procedures of his court. So a federal judge has to use the federal rules of civil procedure for procedural issues, even though they can also work with the substantive laws of other states. I know that's a lot. But that's the issue here, is that there's a lot of precedent out there that says that anti-SLAPP statutes and statutes that allow for early dismissal of cases because they are certain types of cases, because they are against defamation claims and stuff like that, that those are procedural laws. And therefore, they are not enforceable in federal court. They are only enforceable in state court. So Leslie Sloan has filed her motion for attorney's fees using the New York anti-SLAPP statute. And she recognizes that there is some precedent out there that an anti-SLAPP dismissal is a procedural issue. But there in the Second Circuit, which is the federal circuit that we're in, some courts have left open the question as to whether maybe they can provide fees because it's sort of procedural and sort of substantive. but it is very much a reach. She is not guaranteed this. There is no law that says she's entitled to this. Now, her attorneys have done a good job of making all the right arguments, but it is not settled law by any stretch. So she is out there asking the judge to do something that neither that judge nor anybody in that circuit has ever done before, in awarding her over $1 million of fees because part of the dismissal of the case against her came out of New York's anti-SLAPP statute. As for 47.1, and we don't know if Lively is going to file that or not, that is a very similar type of statute. And, you know, it doesn't call itself an anti-SLAPP statute, but that's pretty much what it is, because it provides a procedure by which defamation claims stop in their tracks if they are based on statements or complaints or speaking out about a certain thing. So presumably, if Lively were to file a motion for fees under 47.1, we'd have the exact same legal issue there, which is, can a federal judge award somebody attorney's fees using a state procedural law? In addition to that, on the 47.1, and this is also the one with the treble damages in it, the judge specifically said in the in the concluding paragraph of the order on the motion to dismiss that he had not made a decision based on or otherwise interpreted or applied 47.1 in making his decision. So if he said, I didn't use 47.1 to make my decision, then it stands to reason that he would be disinclined to apply a substantive attorney's fees or treble damages provision under 47.1. So I don't know whether they'll even ask or not, but he was telling them by saying I didn't use it that he is not by any means guaranteed to do that. And just to note, and again, this is in the whole video I did on it before, if someone is awarded attorney's fees, I want to make it clear that that doesn't just mean that you like say, well, this is the number, and then they write you a check. When you recover attorney's fees in any way, in any case, you have to send over all of the bills. They get to authenticate, were these reasonable charges? Is it reasonable to have spent that amount of money? They get to go through all of that stuff and look at it. They then have to send it to a third-party expert who is usually a practicing attorney in that area, who reviews everything as an expert and writes up an affidavit saying what they think is reasonable and what they think isn't. And if they say they shouldn't have paid this much per hour for this person because they only have 2 years of experience, then they put that in the affidavit. And then you take it in front of the judge, and then they decide what you actually get to recover. So it is a whole process in and of itself, and it is a real fucking pain in the ass. So far, Sloan is the only one who has done it. If Lively does it, you know, I think it's a long shot, but I guess she could try. And then the judge has to decide these sort of wonky legal issues of, as a sitting federal judge who only follows the procedures of the federal courts, can I enforce procedural laws from California and New York? Which is a whole thing in and of itself, and the Erie Doctrine, and my lawyers, you know, this is first year law school stuff that gives you a headache. So just FYI, that's the best I can explain it. It's pretty complex. If you have questions, let me know, but that's pretty much what's going on.